Compound crime in aberratio ictus. The circumstance of aberratio ictus, mistake of blow, can neither exempt the accused from criminal responsibility nor mitigate his criminal liability. Matic versus People. However, if the crimes committed against the target victim and the third person who was hit by reasons of aberratio ictus were produced by a single act, the accused is liable for a compound crime. People versus Talampas. Hence, the accused is entitled to the benefit of Article 48 of the Revised Penal Code. However, the accused is liable for separate crimes despite the application of the aberratio ictus rule and not a compound crime if the bullet that killed that target victim is different from the bullet that killed the third person who was hit by reason of aberratio ictus. People versus Flora. Or the crime committed against the third person is merely a light felony, such as slight physical injuries. People versus Violin. Or if the component of a compound crime are alleged in two different information. People versus Umawid. In People versus Adriano, accused treacherously fired his gun several times at his target victim. A bystander was also hit by reason of mistake of blow. Both victims died. Accused is responsible not only for the death of the target victim, but also for the death of the third person, who was hit by a stray bullet. He is liable for two separate crimes of murder. Treachery will be appreciated even though one was killed because of aberratio ictus, but this is not a compound crime, since there is no showing that the victims were killed by single act, but several acts. When various victims expire from separate shots, such acts constitute separate and distinct crimes. Praeter intentionem. Praeter intentionem means unintentional in praeter intentionem. A person shall incur criminal liability for committing an intentional felony, although its wrongful consequence is graver than that intended. Self-help. A landowner surprised a youngster in the act of stealing some fruits in his orchard. He threatened to spank them if they would not come down. Out of fear, all of them jumped from the tree. As a result thereof, they suffered serious physical injuries. A is not criminally liable. Threat to spank them is not a felony. A was just exercising his right of self-help under Article 429 of the Civil Code. Threat to spank is a reasonable and necessary means to repel invasion of his property. Hence, he is not responsible for any direct, natural, and logical consequence thereof. A landowner surprised a youngster in the act of stealing some fruits in his orchard. To scare the intruder, he fired a shotgun aiming at the foliage of a cherry tree. The shot scattered, and a pellet injured the boy, who was standing under the tree. Accused is not liable for physical injuries because he is merely exercising his right of self-help, but he is liable for reckless imprudence resulting in physical injuries. That was reckless in negligence, the Spanish Supreme Court decided. People versus Nukum. Act of an accessory. After the victim was stabbed, the accused assisted the chief actor in throwing the dead body into the well, not knowing that the victim is still alive. Thereafter, the victim died due to drowning. Concealing the body of the crime to prevent its discovery is an intentional felony committed by an accessory. Since death is the direct, natural, and logical consequence of such felonious act of hiding the body, the accused is responsible for as principal in the crime of homicide. He shall incur criminal liability for homicide committed by a principal, although his criminal participation as principal is different from his intended participation as an accessory. People versus Ortega. Physical injuries. The accused punched his pregnant wife. This is physical injuries. If, as a consequence, she and her unborn baby died, the accused shall incur criminal liability for compound crime of parricide with unintentional abortion. People versus Salufrania. With the mitigating circumstance of praeter intentionem. People versus Rabao. Although this crime is different from physical injuries he intended to commit. Unjust vexation. People versus Pugay. The Supreme Court did not apply Article 4 of the Revised Penal Code for death resulting from the act of pouring gasoline, which is part of their fund making, the victim being his friend. In sum, the act of pouring gasoline was not treated as an intentional felony, hence he is not liable for the direct, natural, and logical consequence thereof. The accused was convicted of reckless imprudence resulting in homicide, but the court applied Article 4 for the death resulting from the act of burning the clothes. In sum, the act of burning the clothes was considered intentional felony. Hence, he is liable for the direct, natural, and logical consequence thereof. The accused shall incur criminal liability for homicide, although this is different from physical injuries which he intended to commit. Pouring gasoline over the victim as part of fun making would vex or annoy the victim, but since the mind of the accused is not criminal, such act is not unjust vexation. Hence, the Supreme Court in the Pugay case applied Article 365 and not Article 4, because accused is pouring gasoline is not committing an intentional felony. But if the act is committed with malice and not just for friendly fun making, it will constitute unjust vexation. Malice can be established by showing that the accused is angry at the victim or motivated by revenge or spite. The accused is liable for the direct, natural, and logical consequence of unjust vexation. Article 4 is now applicable. Because of jealousy, accused made plans to get even with a victim, his rival in courting a lady, by scaring him off somehow. The accused placed a rubber snake, which appeared to be real, in the backpack of the victim, with intent to annoy or vex. This act constituted unjust vexation, since the victim died after suffering heart attack. When the backpack was opened, the accused is liable for homicide, which is the direct, natural, and logical consequence of unjust vexation. He shall incur criminal liability for homicide, although this crime is different from unjust vexation, which he intended to commit. 2001. Angered by the imputation of theft made by the victim, the accused tried to scare her by trying to make it appear that he was about to run after over, but he applied the brakes. This act constitutes unjust vexation, since the vehicle skidded because the road was slippery and the victim was hit and died as a consequence. The accused is liable for homicide, which is the direct, natural, and logical consequence of unjust vexation. He shall incur criminal liability for homicide, although this crime is different from unjust vexation, which he intended to commit. 2005. Out of spite and simply intending to put Gina to shame for breaking off with him, Richie emptied a gallon of motor oil on the school stairway where Gina usually passed. Gina, unaware of what Richie did, used the slippery stairway and slipped, hitting her head on the stairs. Since Gina died from brain hemorrhage, the accused is liable for homicide, which is the direct, natural, and logical consequence of unjust vexation. He shall incur criminal liability for homicide, although this crime is different from unjust vexation, which he intended to commit. 2013. Felony producing fear. If a person, in committing an intentional felony, creates in the mind of the victim an immediate sense of danger, which causes such person to try to escape, and in doing so he injured himself, the person who creates such a state of mind is responsible for the resulting injuries. Such intentional felony that creates a sense of danger can be threat. As a result, he shall incur criminal liability for the death of or injuries sustained by the victim, although his consequent crime is different from threat, murder of another victim, or rape which he intended to commit. If the accused committed a crime and as a consequence another crime is committed, these two crimes can be merged into a special complex crime or compound crime, or may be treated as a separate or a single crime. If in the course of robbery the victim jumped out of fear from the boat and died, as a consequence, the crime committed is a special complex crime of robbery with homicide. If after the consummation of rape, the victim jumped out of fear from the building and suffered serious physical injuries as a consequence, the crime committed is a compound crime of rape with serious physical injuries. If in the course of committing murders, the victim without knowledge of the accused jumped from the train and as a consequence died, the accused may be held liable for separate crimes of murder. People versus Tolling. If the accused threatened to kill the victim and by reason thereof the latter jumped from the boat and died, the former is liable for homicide. U.S. versus Valdez. Error in personae and aberratio ictus. X treacherously shot and killed A, who was mistaken by the former as his wife. B, who was hit by mistake of blow, suffered slight physical injuries. X is liable for murder for the killing of A because of error in personae, rule, and slight physical injuries for the wounding of B because of the aberratio ictus rule. This is not a compound crime because slight physical injuries, being a slight felony, cannot be made a component thereof. But if B was hit in his left eye, causing blindness, the crime committed is a compound crime of murder and serious physical injuries. 2015. In aberratio ictus and error in personae, the victim who is killed or injured by the accused is different from the intended victim. In aberratio ictus, the unintended victim was hit due to mistake of blow, which in error in personae, the unintended victim was hit due to mistake of identity. In error in personae, there is only one victim, while in aberratio ictus, there are at least two victims. The imposition of penalty in error in personae is generally subject to Article 49 of the Revised Penal Code, while aberratio ictus is subject to Article 48. Effects on the penalty under Article 49 of the Revised Penal Code. If the penalty for the intended crime is different from that of the committed crime, the court shall impose the penalty of the intended crime or crime actually committed, whichever is lesser, to be applied in its maximum period. Article 49 applies only in error in personae. If the crime committed is parricide but the crime intended is homicide, the penalty for the lesser crime of homicide, which is reclusion temporal, shall be applied in its maximum period. Article 49 is not applicable if the penalty for the intended crime is not different from that of the committed crime. If the crime committed is parricide, but the crime intended is murder, Article 49, which requires the application of penalty in its maximum period, is not applicable because both crimes are punished by reclusion perpetua. I think that is both crimes are punished by reclusion perpetua to death. Article 49 is neither applicable to aberratio ictus nor to praeter intentionem, People v. Gillen. In aberratio ictus, Article 48 may apply where crimes committed against the intended victim and third person who was hit by reason of aberratio ictus were produced by a single act. Praeter intentionem may be appreciated as mitigating circumstance of lack of intent to commit so grave a wrong that committed under Article 13. Evident premeditation. In case of aberratio ictus and error in persona, the Supreme Court did not appreciate evident premeditation since the accused did not premeditate the killing of the actual victim. People v. Trinidad. However, in praeter intentionem, evident premeditation can be considered. They shall be independently appreciated. If the accused premeditated the assault of the victim, but not the killing, and implemented his criminal resolution by boxing, causing his death, both evident premeditation and praeter intentionem shall be appreciated. Treachery. If the accused employed means to render the victim defenseless, treachery shall be appreciated even if the killing is due to error in personae. People v. Del Castillo. In People v. Flora, GR 125909, the accused was convicted of two separate counts of murder for the killing of the intended victim, and the victim hit by a stray bullet. The court, due to the presence of the aggravating circumstance of treachery, qualified both killing to murders. People v. Adriano, GR 205228. Conspiracy. Conspirators are equally liable for the killing of another person due to error in personae, or despite the circumstance of praeter intentionem. However, the rule is different in aberratio ictus. Conspirators who fired at the intended victim are liable for the injuries inflicted upon a third person who was hit by reason of aberratio ictus, but a co-conspirator who never even fired a single shot is not liable for the injuries inflicted upon such third person. The infliction or injury upon the third person is outside the contemplation of the conspirators. Hence, only the actual perpetrators who fired at the intended victim are liable for the injuries sustained by the third person. Proximate cause. Even if the victim is suffering from an internal ailment, liver or heart disease, or tuberculosis, if the blow delivered by the accused is the efficient cause of death, or B has accelerated his death, or C, is the proximate cause of death, then he is criminally liable for the death of the victim. People versus Ulep. Proximate cause has been defined as that cause which is natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury, and without which the result would not have occurred. If the victim suffered heart attack because of the infliction of injuries upon her, and as a consequence she died, the accused is liable for the death of the victim because the physical injuries committed by him is the proximate cause of her death. Although there was no direct injury on the vital organs of the victim, his wounds affected his kidneys, causing multiple organs failure and eventually his death. The accused is liable for homicide. Without the stab wounds, the victim could not have been afflicted with an infection, which later on caused multiple organ failure that caused his death. Efficient intervening cause. The direct relation between intentional felony and death may be broken by efficient intervening cause or an active force which is either a distinct act or a fact absolutely foreign from the felonious act of the offender. X and Y had a heated altercation and then exchanged blows. X pulled out a knife and stabbed Y in the abdomen. Y ran away, but before he could reach his house, he was struck by lightning and died. X should not be held liable for homicide, since the lightning is an efficient intervening cause that broke the relation between the felonious act and death. However, X is liable for physical injuries for the stab wounds suffered by Y. If the victim died due to tetanus of which he was infected at the precise moment when the accused inflicted injuries upon him, or immediately thereafter, the crime committed is homicide. The infliction of injuries is the proximate cause of his death. People versus Cornell. If the victim died due to tetanus of which he was infected several days after, the accused inflicted injuries upon him, the crime committed is physical injuries. The accused is not liable for homicide because tetanus is an efficient intervening cause. Thus, the proximate cause of the death of the victim is not the infliction of injuries. In Villacorta versus People, there had been an interval of 22 days between the date of the stabbing and the date when victim who exhibited symptoms of severe tetanus infection was rushed to hospital. Since the victim was infected of severe tetanus, he died the next day. The incubation period of severe tetanus is less than 14 days. Hence, he could not have been infected at the time of the stabbing, since the incident occurred 22 days before the victim was rushed to the hospital. The infection of victim's stab wound by tetanus was an efficient intervening cause because such infection is absolutely foreign from the stabbing. The accused was held liable for physical injuries. Urbano versus IAC. The delay in giving medical treatment, or failure to receive proper medical attendance, or refusal to undergo treatment for his injuries does not break at all the causal connection between the wrongful infliction of injuries by the accused and the death of the victim. It does not constitute efficient intervening cause because it is not absolutely foreign from the infliction of injuries. The proximate cause of the death of the victim is still the infliction of injuries. Impossible crime. Impossible crime is an act which would have been an offense against person or property were it not for the inherent impossibility of its accomplishment, or on account of the employment of an inadequate or ineffectual means. The offender shall incur criminal liability for committing an impossible crime because of his criminal tendency. Impossible crime is not a real crime since the accused did not commit the crime against person or property, for it is impossible to do so. The law punishes the accused not because of the commission of the crime, but on the basis of his tendency to do so. 2000 Bar. Offender shall be held liable for a possible crime if the following requisites are present. 1. Offender performed an act which would have been an offense against person or property. 2. Offender performed an act with evil intent. 3. Offender did not commit the offense because of the impossibility of its accomplishment or employment of inadequate or ineffectual means. And 4. Offender in performing an act is not violating another provision of the law. Crimes against person or property. Not all impossible crimes prescribed and punished by the revised penal code are punishable. Only impossible crimes against person and property are punishable. Crimes against chastity. Gender is an element of crimes against chastity, except acts of lasciviousness. In seduction and consented acts of lasciviousness and abduction, the offender must be a man, while the victim must be a woman. In adultery, the offenders must be a married woman and man. 2016. While in concubinage, the offender must be a married man and a woman. In corruption of minor and white slavery, the victim must be a female prostitute. If the gender element is not present in a crime against chastity, the crime committed is not impossible crime because the act which is impossible to commit must constitute crime against person or property. If the accused abducted the victim with lewd design and with intent to rape, not knowing that the victim is gay, who underwent gender reassignment, he could not be held liable for complex crime of rape, though forcible abduction, since both components of this complex crime can only be committed against a woman. Nor is he liable for impossible crime of forcible abduction, since this is a crime against chastity. In impossible crime, the act which is impossible to commit must constitute crime against person or property. Neither is he liable for impossible crime of rape, since act constitutes another violation of the law. He is liable for illegal detention. But if the accused abducted a gay who underwent gender reassignment, had sexual intercourse with him, and killed in the course of detention, the crime committed is kidnapping and serious illegal detention with homicide. Having sexual intercourse with a gay merely constitute acts of lasciviousness, which is integrated into special complex of crime of kidnapping with homicide. 2016. Adultery is committed by any married woman who shall have sexual intercourse with a man not her husband, and by the man who has carnal knowledge of her, knowing her to be married. However, one who pretended to be a woman in marrying the complainant cannot commit adultery, since he is not married woman. Neither is his sexual partner liable for adultery, since this crime committed by the man presupposes that woman of whom he had carnal knowledge is liable for adultery. This crime cannot unilaterally be committed by the man. There is no impossible crime of adultery, since this is a crime against chastity and not against person or property. 2015. Prior to RA 8353, rape is a crime against chastity. Thus, if a person raped a dead person believing that she was just sleeping, offender could not be held liable for impossible crime. However, RA 8353 reclassifies rape from crime against chastity to crime against person. Hence, an offender for raping a dead person without knowing that she was already dead may now be held liable for impossible crime. The accused shall incur criminal liability for performing an act which would have been rape were it not for the inherent impossibility of its accomplishment. Crimes against liberty. Kidnapping for ransom consummates at the precise moment when the victim was abducted. Receiving ransom payment is not an element of this crime. What is important is that the victim was kidnapped for purpose of ransom. Hence, impossibility to obtain the ransom payment after the consummation of the crime of kidnapping will not render the crime impossible. Moreover, kidnapping is a crime against liberty. An impossible crime, the act which is impossible to commit, must constitute crime against person or property. Crime against public interest. Forgery involving PCSO ticket consummates at a precise moment when the accused forged the document, and cashing the ticket is not an element for this crime. Hence, impossibility to encash the ticket because its falsity is very obvious after the consummation of forgery will not render the crime impossible. People v. Balmores. Forgery is a crime against public interest. Impossible crime, the act which is impossible to commit must constitute crime against person or property. Evil intent. Stabbing a dead person with intent to kill is an impossible crime. The accused shall incur criminal liability for performing an act which would have been homicide or murder were it not for the inherent impossibility of its accomplishment. Stabbing a dead person with knowledge of his death condition is not impossible crime, since it was not committed with evil intent to kill. The act does not show criminal tendency, which is the basis of penalizing impossible crime, since he is aware that he is not killing someone at the time of stabbing. Factual and legal impossibility. In the United States, criminal laws are silent regarding impossible crimes. Hence, where the offense sought to be committed is factually impossible of accomplishment, the offender shall be liable for the attempted crime. On the other hand, where the offense is legally impossible of accomplishment, the actor cannot be held liable for any crime. In the Philippines, the crime committed is an impossible crime if the offense sought to be committed is factually or legally impossible. In Chud versus Court of Appeals. For example, killing a dead person is an impossible crime because of legal impossibility. Putting the hand inside an empty pocket with the intention to steal a wallet is an impossible crime because of factual impossibility. Impossible crime of theft. If the check is unfunded, stealing the check of the employer by employee and presenting the same for payment with the bank constitute impossible crime. The act of depositing the check is committed with evil intent. The mere act of unlawfully taking the check meant for Mega Inc. showed her intent to gain or be unjustly enriched. There is factual impossibility to accomplish the crime of qualified theft since the check is unfunded. Jacinto versus People. If the check is funded, stealing the check and failure to present the same for payment with the bank will not make the accused liable for impossible crime, even if the accused failed to encash the same due to external costs such as apprehension by police or stop payment, he will be held liable for consummated theft. People versus Seronila. In theft, taking or gaining possession of property with intent to appropriate and to gain consummates the crime. Actual gain is irrelevant as the important consideration is the intent to gain. Thus, failure to gain will not prevent the consummation of the crime. Impossible light crime. The penalty for impossible crime is arresto mayor or fine from 200 to 500 pesos. Article 59. While the penalty for a light felony is arresto menor or a fine not exceeding 200 or both, Article 59 should not be made applicable to one who attempts to commit a light felony of impossible materialization, since the penalty for the impossible crime is graver than that for the consummated light crime. It would be unfair to punish a person who failed to commit a light felony, since it is impossible to accomplish it, for a graver penalty than that for a person who was able to commit it. 2012. It should be noted that RA 10951 failed to modify the penalty of fine prescribed for impossible crimes. Attempted felony. In impossible crime or attempted felony, the offender did not commit the crime, but the difference between the two lies in the external cause that prevents the commission of the crime. If the external cause is the impossibility of accomplishing the crime or the employment of ineffectual or inadequate means, the acts constitute an impossible crime. On the other hand, if the external cause is not the impossibility of accomplishing the crime, but some cause or accident other than his own spontaneous desistance, the act constitutes attempted felony. It is impossible to kill a person using a gun with a dud bullet, but prevented the commission of homicide is not some cause or accident other than his own spontaneous desistance, but the employment of ineffectual means. Hence, the crime committed is impossible crime. 2014. Frustrated felony. If the crime is not committed, the accused may be held liable for frustrated felony or impossible crime, and not for frustrated impossible crime. 2012. If the accomplishment of the crime is impossible, or the means employed in it is inadequate or ineffectual, and thus the crime against person or property was not committed, despite the performance of the act with criminal intent, the accused is liable for impossible crime. For example, the accused, with intent to kill, thought that the salt, which he mixed with the coffee of another, is arsenic powder. Murder was not committed due to employment of ineffectual means. Accused is liable for impossible crime. If the accomplishment of the crime is not impossible, and the means employed to accomplish the felony is adequate and effectual, but the felony was not produced despite the performance of all the acts of execution by reason of causes independent of the will of the perpetrator, the crime committed is frustrated felony. For example, the offender with intent to kill him mixed arsenic with the coffee of another. The latter did not die, not by reason for inadequate quantity of the poison, but due to timely medical intervention. Offender is liable for frustrated murder. Constitutive of another crime. If the accused performed an act constituting impossible crime and another crime, he will be prosecuted for the latter. Arson. firing a gun at the unoccupied bedroom with intention to kill a person who is supposed to be sleeping therein constitutes impossible crime because it is factually impossible to kill the victim who was not in the bedroom. The accused shall incur criminal liability for performing the act, which would have been murder qualified for treachery, by treachery, were it not for inherent impossibility of its accomplishment in Tude v. Court of Appeal. But the throwing of grenade at the unoccupied bedroom where the victim is supposed to be sleeping constitutes arson if the bedroom was burned as a consequence. Serious physical injuries. Accused put a substance to the food of the victim with intent to kill him, not knowing that the substance is not poison or arsenic but powdered milk or non-toxic powder. This is impossible crime. Accused shall incur criminal liability for performing an act which would have been murder by means of poison were it not for the employment of ineffectual means. People v. Palmores. But if the victim, because of severe allergy to powdered milk or non-toxic powder, was hospitalized for 10 days, the accused will be held liable for less serious physical injuries. If the accused administered abortive drugs upon his girlfriend, whom he believed to be pregnant, which turned out not to be true, and the woman became ill for more than 30 days, the accused will be liable for serious physical injuries and not impossible crime of abortion. Acts of lasciviousness. Rape through sexual assault is a gender-free crime. While rape through sexual intercourse is committed by a man against a woman, if the gender element is in rape through sexual intercourse is not present, the crime is not impossible crime, but acts of lasciviousness. Sexually assaulting a victim with intent to have sexual intercourse with her, not knowing that the victim is a gay, is not impossible crime of rape. Although it is impossible to commit rape through sexual intercourse where the victim is a gay, the acts with intent to have sexual intercourse committed against him constitute acts of lasciviousness. Discharge of firearm. A. Discharged shotgun at B from a distance of 300 yards, but because of the limited range of the fire powder of the shotgun, it would be impossible for A to kill B. A is liable for discharge of firearm under A and not for impossible crime of homicide. Trespass for dwelling. Where the offender unlawfully entered a house through the window and took a watch that turned out to be his own, he is liable for trespass to dwelling and not for impossible crime of robbery. Attempted robbery. Accused, being aware that the victim is wearing an expensive watch, threatened him with a revolver. However, the victim left the watch at his home. According to Court of Appeals, Justice Luis B. Reyes, the crime committed is attempted robbery, not impossible crime. There was intent to gain on the part of A when he decided to take the watch of B at the point of gun. The crime of robbery with intimidation is not produced because of a cause or accident that B forgot to carry the watch with him, other than spontaneous distance. Stages of execution. There are 3 stages of felony: attempted, frustrated, and consummated. A felony is at the attempted stage when the offender commences the commission of a felony directly by overt acts, and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. A felony is at the frustrated stage when the offender performs all the acts of execution which would produce the felony as a consequence but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. A felony is at the consummated stage when all the elements necessary for its execution and accomplishment are present. Article 6 of the Revised Penal Code. Preparatory Act. In an attempted felony, the offender's preparatory act requires another act to result in a felony. One perpetrating preparatory act is not guilty of an attempt to commit a felony. People v. Lizada. The intent of the person in committing preparatory act remains equivocal or unclear. Hence, preparatory acts such as buying poison, conspiring and going to the place where the crimes agreed upon will be committed are not constitutive of attempted felony because intent to kill is not clear. However, preparatory acts are punishable if the law prescribes a penalty for its commission, such as proposal or conspiracy to commit rebellion or possession of picklock. If the preparatory acts constitute a felony, committing it is a consummated crime. People versus Lizada. If conspirators, while on their way to the house of the complainant for the purpose of killing him, were arrested by the policeman on the basis of information of one who heard the conspiracy, they are not criminally liable for conspiracy to commit murder, since the revised penal code has not prescribed a penalty for it. Neither are they liable for murder at the attempted stage, since going to the place where they intend to commit a crime are preparatory acts, which are not punishable since the criminal intent to kill, which is an element thereof, is not yet clear. X, Y, and Z agreed among themselves to attack and kill A police officer, but they left their homemade guns in their vehicle before approaching him. Approaching A police officer, is not an overt act of direct assault. This act can be considered as preparatory to the commission of assault. It is not constitutive of attempted direct assault because of the intent to defy the law, and its representative, which is an element thereof, is not yet clear. 2011. Edgardo induced his friend Vicente, in consideration of money, to kidnap a girl he is courting so that he may succeed in raping her and eventually making her accede to marry him. Vicente asked for more money, which Edgardo failed to put up. Angered because Edgardo did not put up the money he required, he reported Edgardo to the police. Edgardo is not liable for proposal to commit kidnapping, since the law has not provided a penalty for it. Proposal to commit a crime is not preparatory act, which is not punishable even as an attempted crime, because the criminal intent to deprive victim of her liberty is not yet clear to the actual commencement of the commission of the crime. Indeterminate offense. In People v. Lamahang, accused who was caught in the act of making an opening with an iron bar on the wall of a store was held guilty of attempted trespassing and not attempted robbery. The act of making an opening on the wall of the store is an overt act of trespassing, since it reveals an evident intention to enter by means of force in the said store against the will of its owner. However, it is not an overt act of robbery, since the intention of the accused, once he succeeded in entering the store, is not determinate. It is subject to different interpretations. His final objective could be to rob, to cause physical injury to its occupants, or to commit any other offense. In sum, the crime that he intended to commit inside a store is indeterminate. An attempt to commit an indeterminate crime is not punishable as attempted felony. If the accused destroyed the door and entered the dwelling of the complainant and was inside the dwelling when the police authorities arrested him, the crime committed is not attempted robbery because of the indeterminate crime principle, but consummated trespass to dwelling. But if the accused admitted his intention to steal, Lamahang principle is not applicable. Hence, the accused is liable for attempted robbery by using force upon thing. People v. Villegas. A enters surreptitiously in the store of B in order to take away with him some articles and hides himself behind the door. But due to the watchfulness of B, he did not dare to come out of his hiding place, where he was discovered. The crime committed is attempted theft. The Lamahang doctrine is not applicable, since the intention of A in this case is to commit theft. Hence, his intention is determinate. In Lamahang case, the intention of the accused once he enters the house is indeterminate. In Cruz v. People, the petitioner climbed on top of the naked victim and was already touching her genitalia with his hands and mashing her breast when she freed herself from his clutches and effectively ended his designs on her. Yet, inferring from such circumstances that rape, and no other, was his intended felony would be highly unwarranted. This was so despite his last for and lewd design towards her being fully manifest. Such circumstances remain equivocal or susceptible to double interpretation. People v. Lamahang. Verily, his felony would not exclusively be rape, had he been allowed by her to continue, and to have sexual congress with her, for some other felony like simple seduction, if he should employ deceit to have her yield to him, could also be the ultimate felony. Attempted and frustrated stages. Attempted felony and frustrated felony are distinguished as follows. Acts of execution. In attempted felony, the offender performed directly an overt act, which is an act of execution, but it is not enough to produce the felony as a consequence. In attempted homicide, the accused performed act to execute his criminal design to kill the victim by inflicting non-mortal wounds upon him, which is not sufficient to kill him as a consequence. In frustrated felony, the offender performed all the acts of execution that would produce the felony as a matter of consequence. In frustrated homicide, the accused performed all acts necessary to execute his criminal design to kill the victim by inflicting mortal wounds upon him, which is sufficient to kill him as a consequence. To determine whether the felony is at the attempted or frustrated stage, the acts of execution of the felony which the accused intended to commit must be identified. Example, the acts of execution that would produce homicide as a consequence are the infliction of mortal wounds upon the victim. If the wounds inflicted upon the victim with intent to kill are non-mortal, the crime committed is attempted homicide. On the other hand, if wounds are mortal, the crime committed is frustrated homicide. Acts of execution in attempted or frustrated felony presuppose that the specific criminal intent required to commit it must be present. Therefore, the external acts performed by the offender and the intended felony must have a direct connection. In homicide, whether frustrated or attempted, intent to kill is an indispensable element. In attempted or frustrated homicide, the accused is performing an act to execute his criminal design to kill the victim. If there is no intent to kill, the crime committed is merely physical injuries. Non-commission of the crime. In an attempted felony, the offender fails to perform all the acts of execution, thus his external acts would not produce the felony as a consequence. On the other hand, in a frustrated felony, the offender performs all the acts of execution, thus his external acts would produce the felony as a consequence, but just the same, the crime is not produced. External cause of the non-commission of the crime. In attempted felony and frustrated felony, the offender failed to accomplish his criminal objective by reason of external causes. If the causes are not external, the accused will be absolved from criminal liability. In attempted homicide, the accused is in order to kill the victim inflicted non-mortal wound upon him, but a policeman immediately arrested him. His timely apprehension is the cause other than his spontaneous desistance, which prevented him from performing all acts of execution or from inflicting a mortal wound upon the victim. In frustrated homicide, the accused, in order to kill the victim, inflicted mortal wound upon him, but the latter did not die due to timely medical intervention. The medical intervention is the cause independent of the exclusive will of the accused, which prevented the consummation of the crime. In attempted felony, if the cause of the failure to perform all acts of execution is the spontaneous desistance of the accused, that is a defense. In frustrated felony, if the failure to produce the crime despite the performance of all acts of execution is dependent on the exclusive will of the accused, that is a defense. Spontaneous desistance. In the attempted stage, offender has not yet performed all the acts of execution. Hence, to be absolved from criminal liability, he must spontaneously desist from performing all acts of execution. In attempted homicide, the accused will be absolved from criminal liability by spontaneously desisting from inflicting mortal wound upon the victim. However, he is liable for the crime that he already completed, such as physical injuries, threat, or discharge of firearm. The term spontaneous is not equivalent to voluntary. Even if the desistance is voluntary, the same could not exempt the offender from liability for attempted felony if there is an external constraint. The term spontaneous means proceeding from natural feeling or native tendency without external constraint. It is synonymous with impulsive, automatic, and mechanical. People versus Lizada. Accused had previously raped the victim several times. During the subject incident, accused was wearing a pair of short pants, but naked from waist up. He entered the bedroom of victim, went on top of her, held her hands, removed her panty, mashed her breast, and touched her sex organ. However, accused saw Roselle peeping through the door and dismounted. He berated Roselle for peeping and ordered him to go back to his room and to sleep. Accused then left the room of the victim. Held, accused intended to have carnal knowledge of victim. The overt acts of accused proven by the prosecution were not merely preparatory acts. By the series of his overt acts, accused has commenced the execution of rape, which If not for his desistance, he will ripen into the crime of rape. Although accused desisted from performing all the acts of execution, however, his desistance was not spontaneous as he was impelled to do so only because of the sudden and unexpected arrival of Rosal. Hence, accused is guilty only of attempted rape. People versus Lizada. Cause dependent on the exclusive will. If the offender performed all the acts of execution, he will not be absolved from liability for frustrated felony, even though he voluntarily desisted from further doing criminal act. Spontaneous desistance is a defense in attempted felony, but not in frustrated felony. If the crime reached the frustrated stage, the offender must do something other than desisting to be absolved from criminal liability. Since all the acts of execution sufficient to produce the felony were already performed, he must do something to prevent the completion thereof. The failure to produce the crime as a defense in frustrated felony must be exclusively dependent on his will. In frustrated homicide, the accused will be absolved from criminal liability by providing medical treatment to save the life of the victim who suffered mortal wounds. If the victim did not die because of the exclusive will of the accused, the latter is not liable for frustrated homicide, but he is still liable for the crime that he already committed, and that is physical injuries. Inflicting non-mortal wound upon the victim by shooting him constitutes physical injuries if the accused did not further shoot him to inflict mortal wounds. The crime is not attempted homicide because failure to shoot him further shows lack of intent to kill. Moreover, spontaneous desistance from further shooting the victim to inflict mortal wound is a defense in attempted homicide. Inflicting mortal wound upon the victim constitutes frustrated homicide even if the accused desisted from further shooting him. The fact that the wounds are mortal indicates intent to kill. Moreover, spontaneous desistance from further shooting is not a defense in frustrated homicide. People versus Abelia. Not absolutory cause. If the felony is consummated, offender cannot undo what was done. He could not be absolved from criminal liability even if he has done something that will mitigate the effect of his felonious act. For example, restitution of funds malversed immediately and voluntarily made before the case was instituted is not an absolutory cause. Navarro versus Meneses. A stole chicken under the house of B, realizing that what he did was wrong. A returned the chicken to the same place where he took it. Since the crime of theft was already consummated, the return of the stolen property does not relieve him of criminal responsibility. A had already performed all the acts of execution which produced the crime of theft before he returned the chicken. The fact that the accused abandoned the victim after 6 days of captivity does not lessen his criminal culpability, much less exempt him from criminal liability for the kidnapping and detention of the victim. Baldogo. Frustrated and consummated felony. In frustrated felony and consummated felony, the accused performs all the acts of execution that would produce the felony as a consequence. If the felony is not produced due to external cause, he is liable for frustrated felony. On the other hand, if the felony is produced, he is liable for consummated felony. There are felonies which has no frustrated stage, since the performance of all the acts of execution immediately consummates them. In homicide, the offender performed all acts of execution by inflicting mortal wounds upon the victim. However, what consummates homicide is the death of the victim. Thus, if the mortally wounded victim did not die due to medical intervention, homicide is only at the frustrated stage. On the other hand, in rape, the offender performed all acts of execution by sexually penetrating the victim's vagina. But since sexual penetration or the touching of the labia of the pudendum consummates rape, there are no occasions where the offender performed all the acts of execution and yet the felony was not produced as a consequence. Therefore, there is no such thing as frustrated rape, since the performance of all the acts of execution immediately consummates the rape. People versus Urita. Belief. Under the old rule, it is not required that the accused actually commits all the acts of execution necessary to produce the death of his victim. It is sufficient that he believes that he has committed all the acts of execution to make him liable for frustrated felony. However, According to Justice Florence Regalado, the belief of the accused as to whether he had already performed all the acts of execution is immaterial. To be frustrated homicide or murder, the accused must have performed all the acts of execution which would produce the felony as a consequence, and not as a matter of belief. In People versus Padayuman, the Supreme Court did not consider the belief of the accused in determining the stage of execution of the crime. Attempted arson. When a person had poured gasoline under the house of another and was about to strike the match to set the house on fire when he was apprehended, he is guilty of attempted arson. The acts performed by him are directly connected with the crime of arson, the offense he intended to commit. The pouring of gasoline under the house and striking of the match could not be for any purpose other than to burn it. Carrying gasoline to the place where the house is to be burned is not attempted arson. Such act is considered as preparatory to arson. It is not punishable as attempted arson because the intent to burn is not yet clear. Accused manifested before his intention to burn the house of the victim to his friends. He then performed the acts of pouring gasoline around the walls of the house to execute his criminal design. To commit arson, this is not just a preparatory act because it already revealed a clear intention to burn the house. He even manifested his intention prior to the commission of the crime. In this case, he already commenced the commission of the crime of arson directly by overt act. But he did not perform all the acts to execute his criminal design to commit arson by setting the house on fire due to cause other than his spontaneous desistance, and that is having been caught by the police. 2015. Frustrated arson. U.S. versus Valdez. Accused soaked a jute sack and a rag with kerosene oil, set them on fire, and placed them beside an upright of the house. However, the fire had been put out on time. The offense committed is not consummated arson because no part of the building had been burned. He is liable for frustrated arson. The accused performed all the acts to execute his criminal design to burn the house, but the house was not burned due to the timely intervention of others who put out the fire on time. Valdez's case is still a controlling principle since there is no case where Supreme Court expressly abandoned it. In fact, in People versus Pon, GR 166401, the Supreme Court said that it is recognized the filing of frustrated arson in the Valdez case. Consummated arson. Setting the building on fire constitute consummated arson if portion of the building was destroyed, People versus Gutierrez, or a small portion of the house was burned. In People versus Hernandez, the Supreme Court ruled that the crime is consummated arson and not merely frustrated arson when the building was partially burned or has been charred. Setting the contents of a building on fire with intent to burn the building consummates the crime of arson of building. This can also be considered as arson of personal property under PD number 1613. Setting the contents of a building on fire without intent to burn the building consummates the crime of arson of personal property. Consummated rape. Touching of either labia majora or labia minora of the victim's pudentum by an erect penis capable of penetration consummates the crime. People versus Campuhan. If there is no touching of the labia, the crime is either attempted rape or acts of lasciviousness, depending upon the intention of the offender. If his intention is to have sexual intercourse with the victim, the crime is attempted rape, otherwise it is acts of lasciviousness. People versus Nuyo. The commission of rape can be established by circumstantial evidence, even if the victim, being the sole witness, was rendered unconscious during its commission. Accused slapped victim and punched her in the stomach. She was rendered unconscious. When she regained consciousness, she found blood in her panties and felt pain in her vagina. Accused was convicted of rape. Acts of lasciviousness. Kissing and undressing the victim, People versus Sanico, or touching her vagina by offender's hand, People versus Banzuela, or rubbing his penis on the mons pubis of her pudentum, People versus Abernilia, is merely acts of lasciviousness because intent to have sexual intercourse is not clearly shown. Attempted rape. To be held liable for attempted rape, it must be shown that the erected penis is in the position to penetrate, Cruz versus People, or the offender actually commenced to force his penis into the victim's sexual organ, People versus Banzuela. Touching her genitalia with his hands and mashing her breast are susceptible of double interpretation. These circumstances may show that the intention of the accused is either to commit rape or simply seduction or acts of lasciviousness, since intent to have sexual intercourse is not clear. Accused cannot be held liable for attempted rape, hence he is only liable for acts of lasciviousness. Cruz versus People. Further, to be an attempted rape, the accused must have commenced the act of penetrating his sexual organ to the vagina of the victim, but for some cause or accidental other than his own spontaneous desistance. The penetration, however slight, is not completed. Attempted rape through sexual assault. In People versus Banagua, the Supreme Court ruled that the touching of the labia of the victim's vagina by an instrument or object, such as tongue or finger, consummates the crime of rape through sexual assault. It seems that the principle in Bonaaga case is not in accordance with the law. Under Article 266A of the Revised Penal Code, rape through sexual assault is committed by inserting an instrument or object into the genital orifice. In People versus Mendoza, the Supreme Court emphasized that rape through sexual assault requires that the assault be specifically done through insertion into the genital orifices of the victim. Hence, what consummates rape through sexual assault is that touching by the object or instrument of the genital orifice of the victim's vagina and not merely the labia of the pudendum.